and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act, laws of the Federation of Nigeria. The defendant pleaded not guilty to the charge when he was arraigned on the 8th July 2021, after the initial legal skirmishes between the defense counsel and the prosecution in relation to issues such as proof of evidence, etc. The trial commences. At the trial, the prosecution called 3 witnesses and tendered the 74.3 kilograms of compressed blocks of dried wheat and other documentary exhibits. The case of the prosecution is summarized below. PW1, Lawal Oyedele Kamal is an officer working with the NDLEA for 10 years. The officer identified the defendant by name and testified that he was among the NDLEA operatives that went out for stop and search operation along Hadeji Nguru Road on the 16th June 2021 at about 10:00 hours in Nguru local government area, Yobe State. According to PW1, a Honda Accord car was driven to the checkpoint by the defendant, who was stopped and told to open the boot of the vehicle to conduct a search, but that the defendant informed the officers that the boot cannot be opened. The NDLEA opened the back door to access the boot of the vehicle. PW1 testified further, when they peeped through the back seat, they discovered that there were some bags and sack in the vehicle, and the defendant eventually opened the boot and brought out 2 black and brown bags and 1 sack, which were opened in his presence, whereby some compressed dried wheat substance were found and recovered. PW1 testified that he arrested the defendant in the presence of other officials of NDLEA, that the defendant was taken to their office alongside the recovered exhibits, the recovered compressed suspected dried wheat, where the defendant was interviewed about the load in his possession. PW1 stated that the defendant responded that one Micaiah communicated with him through phone to deliver the load to one cow in Gedam, Yobe State, and that the compressed block of wheat were counted in the presence of the defendant and witnessing officer, and it was found to be 82 blocks and weighed 74.3 kilograms. PW1 testified further that a sample of the recovered wheat was taken and put inside a white transparent evidence pouch by the exhibit officer, which was taken to Lagos for expert forensic analysis, and that the bulk of the exhibit was kept in the exhibit room by the exhibit officer, who brought out exhibit forms, which was filled and they all signed while the defendant thumbprinted. According to PW1, the statement of the defendant was taken under caution, and the statement of the witness and arresting officer were also taken, and the defendant thereafter detained pending further investigations. PW1 was therefore cross-examined by the defense counsel, SM also Esquire. In his answers to questions put under cross-examination, PW1 told the court that at the earliest possible contact with the defendant, he denied knowledge of what he was carrying, but after much interrogation, he confessed that he went to one Micaiah in Kano. PW1 also testified that the defendant claimed that he did not know the contents of the bags and sacks. Later, when he was pressured, he eventually opened the boot for them. PW1 also testified that up to the time the defendant was transferred from Guru to Damaturu office, the defendant maintained that he did not know the contents of the bag and that he was transferred on the 2nd or 3rd day, and his statement recorded in Damaturu. During the examination, the prosecuting counsel asked PW1 to tell the court why he believed that the defendant has knowledge of the exhibit he was carrying, to which PW1 responded that at the initial stage when the vehicle was stopped and the defendant was informed that a search was to be conducted in his presence, he lied that the boot cannot be opened, that it has a problem, and upon insistence, and not until through the open back door of the vehicle, gave the officials entrance through the back seat, from where they were able to peep at the exhibit that was in the boot. And that when the defendants realized that they have seen the illicit weeds, that was when he opened the booth without any stress. PW2, Albert Michael. This is an NDLA officer working with the Yobe State Command for 11 years, a narcotic agent, that he knows the defendant who was brought to him with pen and statement sheet, that on the 16th of June 2021, he was directed by his superior officer to record the statement of the defendant in Hausa language, to which he read to the defendant the cautionary word to him in Hausa language, after confirming that the defendant had understood the cautionary word, which he affirmed in the presence of his lawyer. PW2 testified that he recorded the statement in Hausa language after asking the defendant to tell him what happened. That after he finished writing the statement, the defendant printed the statement sheet on his portion, and PW2 wrote his name and signed. That all this was done in the presence of his lawyer, SM Arso. PW2 testified that he took the defendant and the statement to the principal staff operations, who read the statement to the defendant, and the defendant understood what PW2 was asked to record, that the PSO endorsed on the statement sheet, to which the PW2 handed the defendant over to a superior officer. The prosecuting counsel asked the witness whether, before handing the defendant over, he interpreted the said statement to him in English language, to which he responded that the statement was recorded in Hausa language and was read over to the defendant, who was further asked whether that was what he told him to be written, and that the defendant answered yes. The witness further testified that he told the defendant that he will translate the statement to English language, and after translating, read the English version to the defendant. During cross-examination, the PW2 stated that he recorded the statement of the defendant at Damaturu on the 16th June 2021, that cannot confirm whether that was the day he was arrested, and does not know whether the defendant was transferred from Guru to Damaturu 3 days after arrest. The PW2 testified that he does not know whether it was after the defendant was definitely transferred that his statement was recorded. When further cross-examined as to whether he had recorded the statement of one Mekaya and one Kawu, the witness replied that he does not know. And when asked whether the defendant is a diploma holder, the witness responded that the defendant told him so while recording his statement, and that the defendant printed the statement in the presence of Saidu, who is in the court. The defense counsel further asked, where is he? To which the witness answered, it is you. PW3 Babudu David. This is an NDLA officer, a superintendent of narcotics, and the exhibit officer attached to the Yobe State Command. He has been with the agency for 11 years now. His duties as the exhibit officer included receiving exhibits arrested with the suspected offenders, testing drug exhibits, weighing them, issuing exhibit forms, which includes certificate of test analysis form, hiking of substance form, request of scientific aid form, keeping the custody of such exhibits, and also testifying in courts in respect of the exhibit. PW3 testified that on the 18th June, the defendant was brought before him by PW1 and PW2, along with 2 traveling bags and 1 sack bag, to which he opened the bags and sack in the presence of the defendant and discovered compressed blocks of cannabis sativa inside the bag and sack, and counted the blocks in the 2 bags and 1 sack to be 82 blocks. The witness stated that he informed the defendant that he wanted to carry out a test, and the defendant affirmed, to which he took a sample of the dried weed suspected to be cannabis sativa and carried out a test, and the test proved positive for cannabis sativa. He also weighed the compressed 82 blocks of dried weed, and it weighed 74.3 kilograms in the presence of the defendant and the arresting and witnessing officers. The witness testified further that he packed the exhibits into two parts, A1 and A3, after taking a sample from the exhibit and labeled the A1 with a number NDLEA/YBSC/011/2021 with the name of the exhibit, dried weed substance, the defendant's name, PW3's name, PW1 and PW2's name, whereby the defendant printed on the exhibit forms in the presence of the arresting and witnessing officers who also signed. The witness testified that he sealed the A1 in a transparent evidence pouch and sent it attached with the request for scientific aid form to Lagos for scientific analysis. He also packed the A3, which is the bulk of the exhibit, and labeled same NDLEA/YBS/011/2021 with the defendant's name, the name of the exhibit, and the weight of the exhibit, 74.3 kilograms, and kept it in an exhibit room under lock and key. At a later date, he returned to the forensic unit at Lagos and collected a large brown envelope with the drug analysis report number NDLEA/SD/2021/1315 and the request for scientific aid form attached. He returned to Damaturu with these documents and kept them under lock and key and brought them to court. The bulk of the exhibit forms, and the large brown envelope containing the analyzed exhibit and drug analysis report were all admitted through this witness in evidence at the trial. Under cross-examination, PW1 confirmed that to the best of his knowledge, this case was transferred from Guru to Damaturu on the 18th June 2021, and also confirmed that the exhibits were sent for analysis, and when further asked by the defense counsel that if somebody says something is proved before scientific analysis, that person is not telling the truth. The witness answered that their own is to do a preliminary test and send it to expert for analysis. And when he conducted the test, it proved positive. The exhibits tendered and admitted in evidence in support of the prosecution's case are also reviewed as follows. Exhibit NDLEA Ibrahim 1, this is the statement of the arresting officer, Lawal O. Kamal, dated 16 June 2021. Exhibit NDLEA Ibrahim 2A, this is the extrajudicial statement of the defendant recorded by PW2 in Hausa language, dated 16 June 2021 and endorsed by Rabiu Garba, ACN. Exhibit NDLEA Ibrahim 2B, this is the translated English version of the exhibit NDLEA 2 as recorded by PW2, dated 16 June 2021. Exhibit NDLEA 3 Ibrahim 3A, this is the certificate of test analysis form on which PW3 stated he wrote the result of the preliminary test he conducted on the drug exhibit NDLEA Ibrahim 5 brought to him by PW1 along with the defendant. He stated that in this form that he tested the sample of the suspected substance with the United Nations testing kit and found it to be positive for cannabis sativa. The form was printed by the defendant as a suspect, while PW1 and PW2 signed the form as witnesses of the preliminary testing. Exhibit NDLEA Ibrahim 3B, this is another NDLEA form named packing of substance form. The substance stated in this form is cannabis sativa. The exhibit was divided into two parts and labeled A1 and A3 respectively by PW3. The A1 was the bulk of the exhibit and the A3 was a sample put in an evidence pouch for expert analysis. This form was printed by the defendant and signed by PW3 as the maker, PW1 and PW2 signed as witnesses of the divisions of the exhibit by PW1. Exhibit NDLEA Ibrahim 3C. This is the NDLEA form name request for scientific aid form. This form accompanied the sample of the exhibit A3 to forensic unit for analysis. It has the name of the defendant on it as a suspect. It carried the laboratory number given to the exhibit by the analyst, and it was endorsed by both PW1 and PW2, as well as PW3, who filled it to accompany the sample he took to forensic unit in Lagos. Exhibit NDLEA Ibrahim 4A. This is the drug analysis report written by the forensic analyst that conducted the analysis in Lagos, confirming that the exhibit A3 hand-delivered by the exhibit A1 hand-delivered by the exhibit officer has tested positive for marijuana cannabis. Exhibit NDLEA Ibrahim 4B. This is the light brown envelope in which the forensic analyst enclosed a sample of the exhibit NDLEA Ibrahim 4C, which he analyzed and addressed to the PW3 with reference number NDLEA YBSC 011-2021 and drug laboratory number NDLEA SD 2021-1315 written there. Exhibit NDLEA Ibrahim 4C. This is the transparent evidence pouch containing the remnants of the analyzed exhibit from forensic analysts attached with the request for scientific aid form. See the evidence of PW1, PW2, and PW3 above. A sample of the dried wheat in a transparent evidence pouch with the case and exhibit number, the weight of the exhibit, the name of the defendant, and the names of PW1 and 2 as witnessing officers. Exhibit NDLEA Ibrahim 5. This is the bulk of the exhibit A3, which is the compressed dried wheat substances, neatly well packaged and taped in brown sellotape and kept in blocks and concealed in one brown bag, one black bag, and one white sack, all amounting to 82 blocks counted in the well of the court, which all weighed 74.3 kilograms, with the case and exhibit number, the weight of the exhibit, the name of the defendant, and the names of PW1 and PW2 as witnessing officers. At the close of the prosecution's case, the defendant chose to give evidence in his defense. He gave evidence as DW1. The case of the defendants is summarized below. DW1, Ibrahim Megari. The defendant is a 28-year-old man that resides at Gaydam, that he was arrested at Nguru with a woman and a child in the car he was driving, that there were two vehicles in front of them that were thoroughly checked by the NDLEA before coming to the defendant. And he was asked what was inside the boot and further instructed to open the boot, which led to the recovered exhibit. And when asked who owns the goods, he replied that the goods was not his, but belongs to one cow, and gave them cow's phone number and volunteered severally by insisting to take the NDLEA to cow at Gaydam, whereby they refused, and the defendant was consequently arrested and taken to the NDLEA office where his statement was recorded. He testified that the statement he gave NDLEA was not the one read out to him. And when he refused to sign or thumbprint and told them that unless they forced him, and one Camille held his little finger and he thumbprinted. The defendant stated that he did not confirm what was given to him by Micaiah because he trusted one cow who was to receive the exhibits, because cow used to borrow the defendant's vehicle when he was a pump attendant, when the defendant was dealing in the business of fuel, and that he engaged the services of counsel at Damaturu. The defendant stated that he has never engaged in this business, never participated in such, and that the NDLEA should go and look for the owner. Under cross-examination, the DW1 was asked, when arrested, you were asked what was in your boot. You said sutura clothing. And further asked to open your boot and the exhibits were found. DW1 answered, yes, I opened the boot without argument. He was further asked in your testimony through your counsel that a gun was used as threat against you when taking your statement. Yet, when the statement was tendered in court, you and your counsel did not challenge same, to which DW1 stated that he was not given the opportunity to respond, and that, yes, I mentioned that my friend borrows my vehicle for personal use, and that friend is the owner of the exhibit. He buys fuel to take it to Niger. He's a friend and a customer. DW1 confirmed that the exhibit was found in his possession, and he was charged with possession. When asked, you have no lawful authority to possess, he answered, even I did not know. Counsel asked him again, you did not present evidence proving that the exhibit was found in your possession without your knowledge. Do you have authority to own cannabis sativa? DW1 answered no to both questions. When further asked, you claim that the cannabis sativa was only found in your possession, but ownership belongs to your friend. DW1 answered, yes, I did not bring the friend before the court to claim ownership. I was not arrested with AK or cocaine. I never used it. When I was arrested, I gave them the number of the owner of the goods. During the examination, DW1 was asked, why did he not bring the friend to testify before the court? To which he replied, I did not see him. He ran away. I searched for him, and I told them to search for him as well. Suka hana ni komai. At the conclusion of hearing, the defense counsel adopted his written address while the prosecuting counsel waived their right to address, and the matter was adjourned for judgment. Above is the summary of the prosecution's case and the defense put up by the defendant on the charge. In criminal trials, such as this one, it is the duty of the prosecution to establish the guilt of the defendant of the offense or offenses charged beyond reasonable doubt in order to secure a conviction. See Section 135, Sub 1 and 2 of the Evidence Act 2011. On the burden and standard of proof in criminal cases and ways of proving the commission of a crime or guilt of a defendant, the Supreme Court held in Arigbibola, Awoshika versus State 2018, LPAL 44351 Supreme Court, that it is well-settled principle of law that an accused person arraigned before any court of law is presumed innocent unless and until he is proved guilty by his accusers beyond reasonable doubt through credible and reliable evidence. See Olayinka Afalolu versus the State 2010-16 NWLR, Okoro versus State 1988 NWLR, Bakari versus State 1957 3 Supreme Court, etc. It needs to be added that the burden of proof does not shift. Once there's the slightest doubt in the mind of the court, such doubt must be resolved in favor of the defendant, who should subsequently be acquitted by the trial court. The defendant is charged under Section 19 of the National Drug Law Enforcement Agency Act, Cap N30, Laws of the Federation of Nigeria, 2004. That section provides as follows. Any person who without lawful authority knowingly possesses the drugs popularly known as cocaine, LSD, heroin, or any other similar drugs shall be guilty of an offense under this act and liable on conviction to be sentenced to imprisonment for a term not less than 15 years and not exceeding 25 years. See Blessing versus Federal Republic of Nigeria, 2015, LPLR 24689, Supreme Court, Okewu versus Federal Republic of Nigeria, 2012, 9 NWLR, Chukuma versus Federal Republic of Nigeria, 2010, 13 NWLR Part 1264-391. In this case, in the instant case, the defendant is charged of being in unlawful possession of 74.3 kilograms of dried weed, which has tested positive for marijuana, cannabis, a drug that is similar to cocaine and heroin. Being a criminal trial, as stated earlier, the onus is on the prosecution to establish the guilt of the defendant by proving all the ingredients of the offense charged. The prosecution is not relieved of this burden, even where the defendant had admitted the commission of the offense. In his statement to the police or any officer after his arrest. This was held by the Supreme Court in the case of Busari versus State 2015-5 NWLR Part 1452-343, in which it followed its earlier decision in the case of Agbadian versus State 2007 NWLR Part 666, 686 at 704. See also Section 135 of the Evidence Act 2011. Therefore, the issue for the court's determination in this case is whether the prosecution has discharged this onus of proof placed on it by law in proof of the charge against the defendant. To determine whether the charge has been proved against the defendant beyond reasonable doubt in view of the evidence called by the prosecution calls for the review of the prosecution's witnesses' testimony, which shows that the defendant was arrested in possession of the illicit substances to which he denied ownership. The exhibits were taken to Lagos to the NDLEA laboratory for forensic analysis, and which result confirmed that the dried weed substances has tested positive for marijuana, cannabis. Thereupon, the prosecuting counsel tendered the bulk of the exhibits recovered as evidence before this court, which the court admitted into evidence and marked it as NDLEA Ibrahim 5. In proceeding to determine whether the charge has been proved against the defendant beyond reasonable doubt in view of the evidence called by the prosecution, in law, the burden of proof that the duty to prove the alleged offenses against the defendant beyond reasonable doubt is static. It squarely rests on the prosecution. It never shifts. There is thus never any duty or burden or onus on the defendant to prove his innocence under any circumstances in our criminal jurisprudence when the prosecution has not proved its case beyond reasonable doubt, or at least on a prima facie basis against the accused person at the close of his case. See Adeyemi versus State 2012 on Federation Weekly Law Report, Part 606-492 at page 505, where the Supreme Court had emphatically pronounced inter alia, thus, in criminal cases, the burden of proof is on the prosecution, who must prove its case beyond reasonable doubt. Thus, the prosecution must discharge this general duty of rebutting the presumption of innocence constitutionally guaranteed to the defendant. This honors, as stated earlier, never shifts. The PW1 testified on the circumstances of the arrest of the defendant. The question is, can the evidence of the prosecution witness on the circumstances of the arrest of the defendant be enough to establish the offense he's charged with beyond reasonable doubt? I note also the extrajudicial statement of the defendant that was not objected to when the prosecuting counsel sought to tender same at the trial and was admitted as NDLEA Ibrahim 2A and 2B. The evidence of PW1 on the mode of arrest of the defendant and how the exhibits was found were corroborated to a large extent by the extrajudicial statement of the defendant. It reads, quote, "After I've been cautioned in Hausa language, which I understand, I freely wish they should record my statement in the presence of my lawyer as follows. My name is Ibrahim Maigari. I'm 28 years old. I was born into the family of Alhaji Maigari Isa, a businessman, while my mother's name is Fatima Suleiman, also a businesswoman in Gaidam, Yobe State. I attended Central Primary School in Gaidam. I also attended Government Science Secondary School Gaidam, which I completed in 2010. I later furthered to State Polytechnic Gaidam, where I studied marketing. I completed in 2013. My father bought a commercial vehicle for my transport business. On 11th June 2021, I went to Kano to see my sick mother. On the 16th June, my car came to me in Kano and collected the vehicle based on the agreement between him and one cow, a Nigerian Republic citizen who usually comes to Gaidam for business purposes. I released the vehicle to my car in the night. At about 11 p.m. on the 15th June 2021, my car came back with the vehicle with some boxes in the vehicle booth. On the 16th June 2021, I took off from Kano with Malama Saudato Ahmad Tahir with her daughter going to Gaidam. Today around 10 a.m., the NDLEA officers stopped me at Nguru and carried out search on my Honda Accord. During the search, some compressed weeds were recovered in my presence from the vehicle. I was arrested and brought to NDLEA office in Nguru alongside the recovered weeds, that is the cannabis, wee. In the office, one black box, one brown box, and a white sack, different colored compressed wee were recovered, which belonged to one cow of Niger Republic citizen. The exhibit was counted to be brown flat compressed wee of 50 pieces and yellow flat compressed wee of 32 pieces, totaling 82 pieces. Everything weighed to be 74.3 kilograms in my presence. All exhibit forms were filled and printed by me and the arresting and witnessing officers. The vehicle belongs to my brother, who didn't know anything about the exhibit. The exhibit was tested and proved positive for cannabis sativa. The statement was made in the presence of Barrister Saidu, my counsel. End of quote. Although the defendant retracted his statement by testifying in court, thus, they arrested me and asked me who owns the goods. I said, they are not mine. I told them the owner and his number and told them the name cow. They tried as I could to take them to the owner. They refused to take me. They took me to their office. At the office, they said they will take my statement, and I told them that I would take them to my car to arrest him. They refused. I was put inside a cell, and I begged to be taken to my car. At last, I was called. I insisted on going to my car, but they refused. I sat on a bench and was told to give a statement. I insisted that I can take them to the owner, which they refused to do. One of them with a gun stated that I either talk or they will wound me. One of them called me aside and advised that I should give my statement. I gave a statement different from the one already read out to me. I told them that I won't unless they can force me to thumbprint. Camille held my little finger, I thumbprinted. The statement made by the defendant, end of quote. The statement made by the defendant and properly admitted in law is the best guide to the truth of the path taken by the defendant. Where, however, it is challenged by the defendant, it is the duty of the court to look into the circumstances under which it was made before it is admitted in evidence. The grounds for objection vary from torture, inaccuracies, forged signature, and misrepresentation. All this must be investigated and ascertained before the admission can be relied upon. In the instant case, when the defendant was arrested, the extrajudicial statement was recorded in the presence of his counsel without any objection. Now, from the above testimony, I find the evidence of the defendant inconsistent. He did not appear to me to be telling the truth when compared to the statement that was made in the presence of his counsel. If he, the defendant, was truly threatened with a gun or forced to thumbprint a document, his counsel will have raised alarm, both during the recording of the statement and during trial. But no alarm was raised by his counsel before the court that the defendant was threatened in any form. No alarm was raised during trial that there are other statements recorded aside the one tendered NDLEA Ibrahim 2A and 2B, which is consistent with the evidence of both PW1 and PW2, the arresting officers and the recorder of the statement as stated earlier. Their evidence corroborates the extrajudicial statement, and I therefore accept the statement as having been proved by their testimonies. From my evaluation of the evidence before the court, the prosecution had proved beyond reasonable doubt that the extrajudicial statement of the defendant recorded on the 16 June 2021 was made voluntarily and without inducement, threats, or promise from a person in authority. More so, the defendant, who did not deny being in concrete possession of the substance or recovered exhibit in his vehicle when arrested, validate that the first ingredient of possession has been proved against the defendant as provided for by Section 19 NDLEA Act Cap N30, Laws of the Federation of Nigeria. Moving on to the second ingredient of the offense charge, that the defendant was knowingly in possession of the substance or exhibits. During trial, the defendant sternly denied being the owner of the exhibit, although he agreed and did not argue that it was found in his possession, with which the prosecution has charged him to court. And his continual insistence that the exhibits belongs to one Kawu, a Nigerian citizen, and was given to him by one Maikaya in Kano. On the other hand, in his statement, NDLEA Ibrahim 2A and 2B, which was not objected to when tendered by the prosecution, the defendant explained how he came to have the exhibits in his possession, but did not deny either categorically or even in passing that he was unaware of what was given to him. The defendant stated that on the 15th June, one Maikaya came to me in Kano and collected the vehicle based on the agreement between him and one Kawu, Nigerian Republic citizen, who usually comes together for business purposes. I released the vehicle to Maikaya in the night at about 11 p.m. on the 15th June 2015. Maikaya came back with the vehicle with some boxes in the vehicle booth. On the 16th June 2021, I took off from Kano with Malama Saudatu Ahmad Tahir with her daughter going together. Today around 10 a.m., the NDLA officer stopped me at Nguru and carried out search on my Honda Accord. During the search, some compressed weeds were recovered in my presence from the vehicle. I was arrested and brought to NDLEA office in Nguru alongside the recovered exhibit, that is the cannabis wiwi. The exhibits found in the defendant's possession, but which he claims he does not have knowledge of when he willingly agreed to give out his car in the night for it to be loaded with boxes and sacks containing the recovered exhibit. The defendant authorized or released his vehicle to one Maikaya based on agreement between the defendant and one Kawu, and again, based on an agreement between Cow Nigerian Republic citizen and one Micaiah. There is nexus between the two individuals and the defendant, whereby criminal intent or prior intention to commit a criminal act with the knowledge that the act is a crime was agreed upon. Hence, the defendant cannot deny the knowledge of what the exhibits are, as there is both mens rea and actus reus on the defendant's part. I so hold. This can be confirmed by the testimony of PW1 during re-examination when asked, what makes you or your team believe that the defendant has knowledge or was aware of the said exhibit in his possession when arrested? The witness answered, at the initial stage, when the vehicle was stopped, the defendant was the one who drove the vehicle, parked the vehicle, and when we told him that we want to conduct search in his presence, he lied that the boot cannot be opened, that the boot has a problem. And when we insisted, and not until we opened the back door of the vehicle to give us access through the back seat, from there we were able to retrieve 2 compressed blocks that were in the booth. When he realized that we have seen the illicit bits, that was when he opened the booth without any stress. Now, the question whether the defendant has knowledge of the exhibits, the reason why he hesitated in opening the booth has been answered in the affirmative, going by the testimony of the defendant himself and PW1, and also corroborated by the exhibit NDLEA Ibrahim 2A and 2B. The defendant stated that he did not confirm what was given to him by Micaiah because he trusted one Kawu who was to receive the exhibit, because Kawu used to borrow the defendant's vehicle when he was a pump attendant, when the defendant was dealing in the business of fuel. Yes, I mentioned that my friend borrows my vehicle for personal use, and that friend is the owner of the exhibit. He buys fuel to take it to Niger. He is a friend and a customer. The defendant confirmed that the exhibit was found in his possession and he was charged with possession. When asked, you have no lawful authority to possess, he answered, even I did not know. Counsel asked him again, you did not present evidence proving that the exhibit found in your possession without your knowledge. Do you have authority to own cannabis? DW1, as a defendant, answered no to both questions. When further asked, you claim that the cannabis sativa was only found in your possession, but ownership belongs to a friend. DW1, the defendant answered yes. I did not bring the friend before the court to claim ownership as defined by law. A crime includes both act or actus reus and the intent to commit the act or mens rea. Criminal intent involves an intellectual apprehension of actual elements of the acts or acts commanded or enjoined by the law. It is usually inferred from the apparently voluntary commission of an overt act. Criminal intent is a prior intention to commit a criminal act with the knowledge that the act is a crime. Thereby, the defendant, although he did not claim ownership of the dried weed substance, but clearly has knowledge of what was in his constructive possession. He in agreement actively gave out his vehicle clandestinely in the night to be loaded with NDLEA Ibrahim 5, contrary to Section 19, NDLEA Act Cap N30, Laws of the Federation of Nigeria, 2004, I so hold. Now on to the third ingredient of the offense, charged that the defendant was in unlawful possession of 74.3 kilograms of dried weed which has tested positive for marijuana, cannabis, or Indian hemp, a drug that is similar to cocaine and heroin. It is one of the hard drugs which the extant legislation, that is the National Drug Law Enforcement Agency Act, Cap N30 Laws of the Federation of Nigeria, 2004, has outrightly, except where lawful authority is shown, prohibited its sale, possession, and or consumption. The prosecution had proved beyond reasonable doubt that the defendant had knowledge of the substance exhibit in his possession and is in unlawful possession of 74.3 kilograms of dried wheat that has tested positive for marijuana, cannabis, sativa, to the extent that I am satisfied and feel sure about it after hearing evidence on either side. The question of fact relevant to the determination of the evidence as to the unlawful possession is proof, so hold. And on to the fourth ingredient, that the drug being confirmed is prohibited or controlled drugs. By the testimony of PW3, the defendant was arrested in possession of the illicit substances. The exhibits were taken to Lagos to the NDLEA laboratory for forensic analysis, and which result confirmed that the dried wheat substance has tested positive for marijuana, cannabis, which is a prohibited substance. From the analysis, it is obvious that the prosecution has disclosed a prima facie case against the defendant, which has not been contradicted. Consequent upon my findings above, I therefore hold that the prosecution has proved its case against the defendant beyond reasonable doubt that the offense of possessing of unauthorized drugs has been established against the defendant. The prosecution, having succeeded in discharging the onus of proof placed on it beyond reasonable doubt, the defendant is hereby convicted as charged. The court will go on to the sentence hearing.
Ascop, please.
The defendant, I would like to hear from the defendant first before I hear from the counsel.
Bisa duka alamun bayanai ya
Take that out.
Francisco Correctional Center, you are interfering with the proceedings of court. Please, can you just keep quiet? Yes, does he have anything to say to the court?
This one is Susenis arrest. Okay, Guru is with him.
Every time I hear you, like, I'm just imagining whether.
I'm not sure where I'm hearing this conversation. If you want to have conversation, the court is in session. You either go out or mute your device. Yes, the convict, go ahead. You say it, let him repeat what he has said, and he should. Yes.
Sorry, my lord, we can't hear the.
Can you speak up? Can you speak up? They can't hear you.
Ina da mata da yara kuma da tsohon ciki a tattare da ita yanzu haka.
Yes.
Sannan ina mai roƙon kotu mai adalci ta duba ko Allah yadda wannan abubuwan da ya faru in Allah yadda zan zama mutumin kirki a cikin al'umma. Zan kula da duk wani tsare haƙƙin wani abubuwa da marasa kyau da yake faruwa in Allah yadda ba zan ƙara shiga al'amuran ba. Wanda zan kasance a cikin al'umma mai zaman lafiya da kare duk wani abu na marasa kyau a rayuwata. Zan kasance wanda zan taimaka al'umma, dukkanin wani al'umma zan kasance mutumin kirki a tattare da su wanda za a ringa alfahari da ni a koyaushe. Sabida daman ni bana harkar wani wanda zai zo shi kamar irin kayan shaye-shaye ko sha ko in zauna da masu sha, sabida ni bana harka da su, abokina guda ɗaya ne wanda nake tare da shi.
Yes. Is that the Convict Council? If you can just unmute your, yes.
This judgment, the defendant has said everything.
Also, I can barely hear you. The convict.
Yes, the convict has said everything that needed to be said.
Yes.
He left out the identification because I have included him.
Just a minute, counsel. Yes.
He is a diabetic patient. I have come to know that he since I started defending him.
He is a diabetic patient and
he is very, very remorseful. He clearly shows that very, very remorseful. If my Lord is lenient with him, I believe.
counsel, I didn't hear that.
My Lord, if this court is lenient with the convict. I believe he will be a better person in future. By contributing the needed quota.
By contributing
His needed quota in the community in which he lives. And take care of his aged mother, which are ready. My Lord, in the light of all this, despite the quantity of the substance, I urge my Lord to be lenient with the convict. Thank you, my Lord.
sentence. Having listened to the plea mitigation made by the convicts as well as the defense counsel, the court is required, especially in cases involving illicit trafficking in narcotics, to take into consideration the nature of the drugs involved. In this case, it was cannabis sativa that the defendant was convicted of being in unlawful possession. The provisions of the NDLEA Act stipulates different regimes of punishment for unlawful possession of cannabis sativa in contrast with such other hard drugs and psychotropic substances. The court in such cases will consider the amount or the quantity found in possession of the defendant or of the convicts when arrested. This enables the court to ascertain whether the convict is a mere user or abuser of hard drugs, or is someone who is either a retail or commercial dealer. By considering the quantity of the hard drugs, it enables the court to assess the extent of harm which the defendant or the convict has done to himself as a consumer or to the society as a retail or commercial dealer in illicit hard drugs. Again, the location of the arrest of the defendant is an important consideration because the court always frowns at a defendant who attempts to transport hard drugs from one part of the country to another, as in this case. In view of the fact that in this part of the country, the populace are grappling with insecurity, the court will not likely to be lenient with such a defendant. The court in relation to such defendant who attempts to transport will also be concerned with the mode of concealment. This enables the court to assess the defendant as either an incorrigible dealer or trafficker or a novice who has only been introduced into the illicit business. The factors which the court will consider are almost inexhaustive, all being an effort to locate the station in life of the convict in order to impose such punishment as will meet the justice of this case. This is the reason why, in my view, judicial sentencing is perhaps the most important aspect of criminal justice and adjudication process, because it is in this regard that the law comes out real to the defendant or convict and to the larger society. A casual attitude by the court to these issues will invariably lead the court to impose a sentence punishment that may be too harsh as to defeat the attainment of the goal to seek the reform of the convicts, and which may invariably impair the attainment of even the goal to seek for deterrence in both the convicts and the larger society. In criminal jurisprudence, the two broad goals of judicial sentencing are, firstly, to seek the reform of the convict so that by the time he completes the penal custodial sentence, which the court imposes, he will return to the society as a better and more responsible citizen who has respect for laws of the land. The second goal is to impose such sentences as will serve as deterrence to the other persons who are yet to be caught by the proverbial arm of the law, who are also involved in similar acts for which the convict is being punished. While the first goal focuses on the convicts in the dock, the second goal, in my view, focuses on both the convicts in the dock and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced. Having listened to the plea mitigation as stated earlier, which made by the convict as well as the defense counsel, the court having taken all that into account in passing sentence on the convict, I take consideration that it's a first-time offender before this court. But again, imagine how many people's life would have been destroyed if the 74.3 kilograms of cannabis sativa was not recovered from the defendant's possession. There's need to give a deterrent sentence to send the message that such acts are not acceptable. Having said that, I hereby sentence the convict to 5 years imprisonment. The sentence shall be deemed to have commenced from the date of arrest. In the final analysis, the 6 drugs being 82 blocks of dried weeds, which has tested positive for marijuana cannabis, admitted as exhibit NDLEA Prime 5, and which weighs 74.3 kilograms, are hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibits shall be destroyed by burning by the NDLEA along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. The said event shall be witnessed on NDLEA's invitation by representatives of the Nigerian Police Force, the Department of State Security Service, and Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence of the convict, which sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to the society as a changed person. The convict may not be so lucky in future if he's caught and charged for a similar offense. This shall be the court sentence. Appeal. The convict has 90 days within which to appeal both the conviction and sentence if it's not satisfied with same. Obiter, the Defense Counsel adopted his final written address on the 12th July 2023, while the prosecuting counsel waived his right to address. On that date, the matter was adjourned for judgment to a date that would be communicated to counsel. But the intervening court's long vacation and other public holidays affected the writing and delivery of the judgment within 90 days. Please note that by the provisions of Order 46, Rule 6 of the Federal High Court Civil Procedure Rules 2019, time shall not run during the long vacation, Christmas vacation, Easter vacation, and public holidays.
My lord, you are very grateful for the judgment.
Thank you. Sorry. Arrest. He is from, it seems he is from a very good home. So he should not just immediately after his sentence, his remand, he should turn into a good person in the society as he promised in court. Thank you. Please call the, is the prosecuting counsel online? Prosecuting counsel has disappeared again. Can you call the prosecuting counsel? What's happening? Prosecuting counsel?
Thank you for Not going.
Since the prosecuting counsel is having challenges rejoining the proceedings.
Prosecuting counsel.
Call the case, please.
My lord, I apologize, my lord. My gadget overheated and
Gotcha model.
Hold the case.
For the case, judge number FS/DM/CR/44/2023 between the Federal Republic of Nigeria and Gotcha model.
Correctional Center.
Good morning, my lord. We are together Penda here at the care center.
Representation.
with the greatest respect and much honor, my lord, my name is Usman Bamala. My humble appearance is for the complainant.
Defense counsel. Defense counsel. It seems as if you are muted. Can you unmute yourself? Defense counsel. You're muted. We can't hear you. Can you speak up? The loudspeaker on your gadget may be too low. I still cannot hear you. I don't know where the you are AI Waziri Esquire. As long as we can't hear you. Please call, why did you, because the next case to be called is Yusuf Usman. Why did you call the third case? Call the third before you check this case. Taking too long.
Judge number FS/DM/CR/2023 between the Republic of Nigeria and Yusuf Usman.
Yusuf Usman.
Present here, my lord. Here at the correction center together with the defendant, Yusuf Ibrahim. Yusuf Usman, he speaks.
Okay.
With the greatest respect and much honor, my lord, my name is Usman Bamala. My humble appearance is for the complainant.
Yes.
My lord, the matter is fixed today for review of fact of this case, my lord. And subject to the convenience of my lord, we are ready to proceed.
Go ahead.
My lord, the complainant intends to review the fact of this case through the exhibit officer, my lord. My lord, with the leave of this honorable court, we apply for the exhibit officer in person of Mr. Muhammad Rabiu Suleiman to step into the witness box, my lord.
My lord, the PW1 is here at the correction center together with me. He is ready to affirm. My lord, let me affirm myself first. I, Salih, do solemnly affirm and interpret court proceedings from English to Hausa language and vice versa to the best of my ability. So help me God.
I, Sulaiman Mohammed Rabiu, do solemnly affirm the evidence that I shall give before this honorable court in this case shall be the truth, nothing but the whole truth. So help me God.
My lord, the PW1 is affirmed. He is male, adult, and a Muslim. Wannan shi zai bada shaida akan tuhumar da ake yi maka.
Once again, tell this honorable court your name.
My name is Sulaiman Mohammed Rabiu Sulaiman. I work with the National Drug Law Enforcement Agency of State Command.
For how long have you been working with the agency? For how long have you been working with the agency? Can you hear me?
Yes, 3 years, my lord.
What rank did you attend so far?
I'm a chief narcotic agent.
Good. Tell this honorable court for all these 3 years, what are your schedule of duties?
Receiving of suspects and the exhibit recovered from them, carrying out a field test on the recovered exhibit, weighing of the exhibit, packing of exhibit into A1 and A3, A1 to be sealed in an exhibit pouch, while the A3 to kept in an exhibit room for safekeeping, issuing of exhibit forms for the witnessing and arresting officers to sign, and also for the defendants to thumbprint on them, and any other ad hoc duty given to me by my commanding officer. Thank you, my lord.
Tell this honorable court, what do you know about the defendant in respect of this matter?
Let him interpret to the defendant.
Wannan an tambaye shi ne ya sunansa, ya faɗi sunansa, shekararsa nawa da fara aiki, yace ya kai shekara 3 yana aiki. Yace aikinsa gudanar da bincike akan shingen bincike zuwa kuma ya zo ya ba da saida kamar yadda ya tsaya yanzu haka a gaban kotu. Shine aikinsa, abin da ya faɗa kenan.
Yes.
On the 12th of January 2023,
yes, go ahead.
okay, the defendant was brought before me by Badamasi Yakubu Saleh, NA, and Mustafa Mohammed, NA, along with a black polyethylene bag. I asked the defendant who owns this black polyethylene bag, and he replied that the bag belongs to him. When I opened the black polyethylene bag, I discovered that there are some dried leaves suspected to be cannabis sativa. I asked the defendant that I want to carry out a field test, and he gave me the After carrying out the field test, the test proved positive for cannabis sativa, and it was also weighed, and it weighed 700 grams, my lord.
Yes.
I took some part of the exhibit and sealed it in a white evidence transparent pouch, which will be taken to Lagos for scientific analysis.
Yes.
Thereafter, I then issue some exhibit forms, namely certificate of test analysis, request for scientific aid forms, packaging of substance form. I fill the necessary columns. Witnessing and arresting officer also sign their own column, and the defendant thumbprint on each of the forms. Then I took the bulk of the exhibit, that is A3, and kept it in an exhibit room for safekeeping. On the 11th of April, 2023, I took the A1 to Lagos for scientific analysis. And on the 12th of April 2022, I received a response calling my attention Mohammed Rabi Suleiman, Exhibit Officer, NDLEA Yobe State Command, along with a brown envelope attached with the brown envelope is the result for scientific analysis. That's all, my lord.
Let him interpret.
Wannan mai gabatar da saida, kana ji? Ya ce wata rana ofisoshinsu sun same ka da wata bakan leda, ciki akwai wasu abubuwa wanda da aka bude aka gan shi wani busasshen ganye ne, wanda ake zargin tabar gurbi ne. Ya ɗau wannan abin da ofisa ya zuba a leda a gabanka, saboda za a kai wa ƙwararru su bincika shin wannan abin haka ne, busasshen ganyen ana zargin wiwi ɗin shi ne, to an ɗauka an kayi Lagos wajen ƙwararru sun gudanar da bincike. Sakamako ya bada cewa lalle wannan abin da aka samu shi wiwi ne, shi ne ya bada saida.
Mr. Rabiu Muhammad Suleiman,
Yes,
in the course of your testimony before this honorable court, you made mention that you filled some exhibit forms.
yes, my lord.
In which the defendant equally affixed his thumbprint on it.
Yes, my lord.
Thank you very much. You further stated that you equally took a sample of the exhibit found in possession of the defendant for forensic analysis to Lagos, in which you received a response in a brown envelope.
Yes, my lord.
They said scientific documents together with the forensic analysis report with you before this honorable court.
Yes, my lord.
Can you tell this honorable court how you will be able to identify all the scientific documents together with the drug analysis report, forensic analysis?
All the documents, my lord. My name is written there, and the name of the suspect, and the name of the defendant, and also the date of documentation.
My lord, we apply for the witness to present the said documents, my lord, for identification, my lord.
Go ahead.
These are the documents, my lord.
Yes.
You need to show the court for the purpose of identification which one is which.
This is packing of substance form. This is certificate of test analysis. This is the brown envelope. This is drug analysis report. This is certificate request for scientific aid form, my lord.
My lord, in the circumstances we apply to for the witness to open the said brown envelope to ascertain what it contains, my lord.
Go ahead.
My lord, this is the evidence of the scientific analysis.
Yes.
My lord, in the circumstances, we sought to tender the packing of the substance form, the certificate of the test analysis, request for scientific aid form, the drug analysis report, the white exhibit pouch containing the remnant of the exhibit, and the brown envelope in evidence before this honorable court.
Interpret to the defendant.
Wannan shine takardar da aka kawo sakamako daga can Lagos. Wannan kuma shine abin da aka ɗebi samfur a cikin abin da aka samu a wajenka, aka je aka gwada. Wannan kuma shine sakamako da aka kawo na cewa lalle ya tabbata wannan din da aka samu tabar wiwi ce. Ka gani?
The following exhibits hereby admitted into evidence. The exhibit forms comprising of the certificate of test analysis form, packing of substance form, request for scientific aid form, hereby marked as NDLEA Yusuf 1A, 1B, and 1C. The drug analysis report marked as NDLEA Yusuf 2A. The white transparent evidence pouch marked as NDLEA Yusuf 2B. The brown envelope marked as NDLEA Yusuf 2C, respectively.
Mr. Rabiu.
Yes, my lord.
You said you kept the bulk of exhibit in your custody for safekeeping.
Yes, my lord.
I believe when you kept the said bulk of exhibit, you affix a mark or you write something that will serve as an identification on it.
Yes, my lord.
Can you tell this honorable court what are those means of identification, how you will be able to identify the said bulk of exhibit?
The name of the defendant was written there. Date of documentation was also written there, and NDLEA case number is also written there, my lord.
My lord, in the circumstances we apply for the witness to bring forward the said bulk of exhibit for identification.
Yes, go ahead. Counsel.
My lord.
What is, yes, go ahead. We are waiting for you.
My lord, thank you. My lord, the camera just took away from the correction center. That was the reason why I kept mute. I can't see them until now, so my apologies. My lord, we apply for the witness to open the said bulk of exhibit, my lord, for identification, my lord, to ascertain the said bulk of exhibit.
Go ahead. Take some granted.
This is my lord.
Yes.
My lord, having ascertained the said bulk of exhibit, we sought to tender same in evidence before this honorable court.
You just said this is, what is it?
My lord, it's like half block of it wrapped in a black nylon.
Wrapped in black.
Nylon, my lord.
Yes.
And then delay case number is NDLA YBSC 003-2023. 003-2023.
My lord, in the circumstances having ascertained the and identified the said bulk of exhibit, we sought to tender same in evidence before this honorable court.
The bulk of the dried, of half a block, compressed blocks of dried wheat, wrapped or concealed in black polythene with NDLEA number YBSC /003/2023 is hereby marked as NDLEA Yusuf 3.
Stop, please. Stop, please. My lord, that's all we have for the examination in chief in this matter.
Yes, ask the defendant, show the defendant the exhibit and ask him whether these recovered exhibits were the ones found in his possession when he was arrested.
A lokacin da aka same ka wannan shine aka samu a wajen ka? Ka ɗaga murya.
Wannan ne.
He said yes, man.
Does he have any questions to ask the exhibit officer, the witness,
Kana da wata tambaya
on what has transpired so far?
Akwai wani tambaya da kake so ka yi wa shi wannan wanda ya bada saida?
Gaskiya babu.
Yes.
My lord, we have no examination since there is no any cross-examination. We apply for the witness to be discharged from the witness box.
Application granted. Thank you, officer.
Thank you, my lord.
My lord, we will equally sought to tender the statement of the defendant, my lord, both the English and Hausa version across the bar.
Application granted.
Stop, please. My lord, that's all we have for the examination in chief and for the review of fact, my lord, in a nutshell. My lord, we urge this honorable court to convict the defendant as charged.
The extrajudicial statement of the defendant in Hausa language and the translated version in English language marked as NDLEA Yusuf 4A and 4B respectively.
Stop, please. My lord, we apply for the court to convict the defendant as charged?
Ask the defendant whether the facts as stated by the prosecution and the exhibits as presented by the exhibit keeper, as well as the statements as presented by the NDLEA officer, reflected the true position of the case.
Wannan jawabai da mai ba da shaida ya bayar a kanka da kuma abin da aka samu a wajen naka duka, ko kana da wani ja a kai ne haka, ko da wani abu da aka ce? Ba ni da wani ja a kai.
Those the statements and the other exhibits reflect the true position of the case.
Jawaban da aka ɗauka kuma haka ne akan maganar gaskiya haka ne.
Whether the defendant has any cause to show why he should not be convicted as charged.
Kuma ko kana da wani dalilin da zai sa da kake da shi wanda za ka gabatar da sa ba za a hukunta ka ba? To ka to. Ya mai girma mai shari'a.
Does he have any reason why he should not be convicted as charged?
Akwai lokacin da aka yi wannan magana ba yanzu ba ne. Yanzu akwai wani dalilin da kake shi wanda ya sa ba za a maka hukunci ba? Ba ni da wani dalili.
The defendant who indicated that he was not literate in English language had the charge dated 17th January 2023 and filed on the dated 13th January 2023, filed on the 17th day of January 2023, read and interpreted to him through a sworn interpreter. He pleaded guilty to the 2 counts in the state charge. The learned prosecutor consequently indicated his intention to conduct a review of the facts of the charge. This was an exercise which is peculiar to drugs and related offenses and was not meant to require the prosecution to prove the allegation in a criminal charge, which the defendant had voluntarily pleaded guilty to by the provision of the law, except in capital offenses. Once a defendant has pleaded guilty to an indictable felony punishable with a term of imprisonment, the court is empowered, especially in relation to the Federal High Court, who by Section 33, Sub 2 of its enabling Act, Cap F12, Laws of the Federation of Nigeria, 2004, empowered to try criminal cases and matters summarily, to proceed to convict the defendant. The exercise to do a review of the facts of the charges of the charge was consequently done now. I've listened to the learned prosecutor Usman Bamala, who has produced certain documentary and real exhibits which have been admitted in evidence. Exhibits Yusuf 3 being the bulk of the exhibits seized and recovered from the defendant on the 9th day of January 2023 in the course of follow-up operations by NDLEA officers is cannabis sativa. It is one of the hard drugs which the extant legislation, that is the National Drug Law Enforcement Agency, has Act Cap N30 Laws of the Federation of Nigeria has outrightly, except where lawful authority is shown, prohibited its sale, possession, and or consumption. The defendant, who on arraignment pleaded guilty to the charge dated 13th January, has not produced any evidence of lawful possession of exhibits. Yusuf 3, I'm satisfied against his plea of guilty and the field-tested proof of exhibits that the case against the defendant has been proved beyond reasonable doubt as is required by sections 137 and 138 of the Evidence Act 2011. In view of the plea of guilt entered by the defendant and in line with the provisions of sections 2741 and 2 and sections 3561 and 2 of the Administration of Criminal Justice Act 2015, this court hereby find the defendant Yusuf Usman guilty of knowingly without lawful authority in possession of 700 grams of dried weed substances and narcotic drugs similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Sections 19 and 14 of the NDLA Act, Cap N30, Laws of the Federation of Nigeria, 2004. The defendant, Yusuf Usman, is hereby found guilty and convicted and as charged. I shall listen to the allocators of the convict before I pronounce on his sentence. This shall be the judgment of this court on the basis of the charge dated 13th January and filed 17th January 2023. Any record of previous conviction?
My lord, the convict has no previous record of conviction, my lord. It is worthy of note that the defendant, my lord, has not suffered investigation, and the convict also, my lord, have suffered a long period of detention, my lord, at the correction center, my lord, before the conclusion of this particular case, my lord. I urge my lord to consider the aforesaid as a part of mitigating factors. My lord, as part of the aggravating factor, which I noticed from the extrajudicial statement of the convict, my lord, the convict understood that he has to, after testing the variety of the cannabis, my lord, he decided to take it to another state to his, which most of his friends are vigilantes, my lord, for them to have a taste of it, my lord. My lord, I urge this honorable court to consider the said as part of aggravating factor. Thank you very much.
Ask the defendant, does he have anything, the convict, does he have anything to say to the court?
Yanzu ko akwai wani abu da aka iya faɗa wa kotu yanzu? Kana
My lord, ina roƙon wannan kotu mai daraja, mai adalci, da ta yi mini sassauci bisa laifi da na aikata, ta yi mini sassauci bisa hukuncin da za ta yanke mini. Sakamakon ni ɗaya ne a wajen mahaifina, ni ne namiji babba a wajen mahaifina da mahaifiyata, sannan kuma kanne da nake da su duka ƙanana ne kuma mata ne. Wannan abun ya faru da ni ne sakamakon ni ba mai sayarwa.
I'm writing. Tell him that he should speak gently. I'm writing.
ana rubuta jawabanka kana yi a hankali hankali.
Ina roƙon wannan kotu mai daraja mai adalci da ta yi mini sassauci bisa hukuncin da za ta yanke mini. Sakamakon laifi da na aikata, ina roƙonta alfarma da ta yi mini sassauci.
Yes.
Bisa hukuncin da za ta yanke mini. Za mu yi girma mai shari'a. Ina neman alfarma da a yi mini sassauci.
Yes. Is that it?
Za mu yi girma mai shari'a. Sakamakon ni kaɗai ne a wajen mahaifina.
Yes.
Kanne da nake da su kanana ne kuma duka mata ne. Sannan kuma ba ni da wani sana'a wanda ya wuce noma. Babana ya riga da ya tsufa, sannan yana da ciwo na asma wanda take damun shi baya iya yin aiki. Da taimakon Allah da kuma noma da nake mana da shi ne muke samu muke ci muke sha. Wannan abu da aka kama ni da shi ba shi ne sana'a na ba. Ina saya ne domin amfani da shi da nake wajen dafa shi a shayi. Nakan saya da dama irin haka yakan kai tsawon wata 2 ko zuwa 3 ina amfani da shi. Sai kuma ina roƙon wannan kotu mai daraja da kuma godiya a wannan kotu mai daraja da ta zama sanadi na ajiye ni a gidan wannan gyara na hali da ta yi. Na tsawon watanni da ne a cikin wannan gida na gyaran hali. Na zauna na gani da dukkan wani abubuwa da nake aikatawa mara kyau. Na riga da na yi nadama sakamakon ba na samun wannan abu da nake amfani da shi wanda tun dama ina so in bar shi kuma ya gagara. Yanzu na riga da na yi nadama na daina shi ba zan ƙara amfani da shi ba in Allah ya yarda.
How long has he been using this substance? For how long?
Ina amfani da shi ne tsawon shekara 2.
2 years, my lord.
This the review of facts consequently done, the court will sentence the convict shortly.
As court please, ma'am.
As the court pleases.
Sentence.
Scott, please, my lord.
Scott, please.
On the 14th day of February 2023, the convict Yusuf Usman hearing was adjudged guilty of the indictment in the charge sheet dated 13th January and filed 17th January 2023, based on the plea of guilty which he entered when he was arraigned. The review of facts consequently done, and the defendant convicted, and the court, on deeper reflection, hand down the appropriate sentence which will meet the justice of his case. Because as stated earlier, I said the two broad goals of goals of judicial sentencing are first to seek the reform of the convict, so that by the time he completes the penal custodial sentence which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land. Having listened to the convicts, I think the convict is reformed. The second goal is to impose such sentence as will serve as a deterrent to the other persons who are yet to be caught by the proverbial long arm of the law, who are also involved in similar acts for which the convict is being punished. While the first goal focuses on the convict in the dock, The second goal, in my view, focuses on both the convicts and the dog and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced. Salisu, do you want me to continue, or do you want to bit by bit to translate?
I will interpret in my lord in Hausa now.
Okay, go ahead. Thank you.
Thank you, my lord. Kana ji ba? Kotu ta yi la'akari da dubi da yadda ka kasance mai laifi kuma ka ansa bata wahala ba, baka wahalar da kotu ba. Shine yanzu kotu take dubawa da hukuncin da za ta yanke maka din, sai ta ce ya kamata a ce an sassauta maka, kuma in ka fitar kai kuma za ka kasance mai gyara a wasu, bisa ga zama da kai a nan gidan gyaran halinka, ka ɗau darasin da wani ma za ka hana shi ya yi, ba wai za ka ci gaba da yi ba ne. As God please, my lord.
Thank you. In relation to the convict, the sentence the court will impose is to be such as will deter him from going back to the same or similar activity as constituting the offense for which he's been punished. While for the other persons out there who are yet to be caught in the web of the law, persuade them to desist on pain of similar punishment from continuing with or not to go into similar activity.
Kuma kamar wannan laifi da ka aikata, ana so ka kasance makamancin irin sama, baka da wani alaƙa da shi, ko da wani mai irin sama ka nisance shi saboda gyara rayuwarka.
I took the opportunity to read the extrajudicial statement made by the convict, which was in the court file portion to Section 122 Evidence Act. And I've also listened to the convict in his plea during mitigation. I have the impression of a young man who uses narcotics for pleasure, as he uses it as an infusion to drink like tea. And he confesses that he started the habit 2 years ago and struggling to stop. And by remanding him in Pottiscombe Correctional Center, he does not have access to same and is willing to change for the better.
Yanzu kimanin shekara biyu da kake a kimanin shekara biyu kana gudanar da wannan, ka yi dalilin da dama wanda suke samun wannan abu daga wajenka. Yanzu kuma kaga kimanin kusan watanni kana ra'anan, kaga ba sa samun wannan abu. Kuma sannan ana ƙara baka shawara da cewa duk hukuncin da aka ma in ka gama shi, in ka fita din, ka zama mutum da gari, ka daina mu'amala da shi ta harkar abin da kake sayarwa, shayi ko wani abu da kake sayarwa, ka daina da shi, shine shawarar da ake ta jan hankalinka a kai. Scott, please, my lord.
He didn't say he's selling, and I didn't say he's selling either.
Yawwa, sannan sayarwa fa.
I did not, Sally, he did not say he's selling, and I did not say he's selling. Do you understand?
Yeah, I understand, my lord.
So yeah, it's like you have made a mistake. Now, by the provision of Section 19 of the NDLEA Act, SOPRA, the maximum punishment prescribed by the law upon conviction is to be sentenced for imprisonment for a term not less than 15 years and not exceeding 25 years.
Dokar nan ta hana sha da safarar miyagun ƙwayoyi ta ƙasar. Hukuncin baya ƙasa da shekara 15, sannan kuma baya yin sama da shekara 23, shekara 25. Don haka shine zaka ji hukuncin.
However, having regard to the considerations which I had analyzed, the fact that the convict readily pleaded guilty to the charge immediately upon his arraignment, and of the fact that he appears remorseful, are factors which ought to inform the sentence which this court will pass.
Kuma in aka yi la'akari da kaman hukuncin, abin yana da tsauri sosai, amma dai kotu duk da aka ta dubi da yadda ta ga ya dace a hukunta kan.
Although the quantity of the hard drugs recovered from his possession was 700 grams, And he said he used to buy same and keep using it gradually for up to 3 months, which betrayed him as a consumer.
Kasancewar ka kana sayanta kamar wanda aka yi amfani da ita ta wata uku, kana amfani da ita a wajen yin kasuwancin naka, kana sha kenan da ce, to kaga hakan da aka haɗa shine kimanin gram 700 nauyin ta din, to kaga dan haka laifin naka yayi kai laifi.
In the final analysis, the convict is hereby sentenced to 10 months imprisonment for the one-count charge against him. The sentence shall be deemed to have commenced from the 14th day of February 2023, when the defendant was arraigned before this court, which means that the defendant has almost finished his sentence.
As court, please. Shine yanzu alkali ta ce a gaya maka kotu ta ɗaure ka wata 10. Kaga in aka yi da aka yi da dubi kusan ma ka yi zaman naka a cikin wannan gidan a yanzu. Saboda daɗewa.
You seized drugs being cannabis sativa admitted as exhibit NDLEA Yusuf, and which weighs 700 grams, is hereby confiscated and shall be forfeited to the federal government of Nigeria and shall be destroyed by burning by the NDLEA along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. The said event will be witnessed on NDLEA's invitation by representatives of the Nigerian Police Force, the Department of State Security Service, and the Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the sentence of the convict, which I deferred today in order to reflect deeply on the appropriate sentence. The sentence is no doubt very light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to his family. The convict may not be so lucky in the future if he's caught and charged for a similar offense. This shall be the court sentence.
As court, please. Yana da kyau ka ƙara godiya a kotu saboda hukuncin da ta yi ma hukunci ne mai sassauci. Kai godiya sosai a kotu. Hukuncin da aka ma yana da sassauci sosai, kai godiya.
Ina matuƙar godiya sosai ga wannan kotu mai daraja. Idan Allah ya yarda na yi nadama zan iya kasance masu wa'azi ga sauran mutane da suke aikata irin wannan abun, sannan kuma wanda suka kiya zan guje su. Zan yi nisa da su, ina matuƙar godiya sosai.
The convict has 90 days within which to appeal both the conviction and sentence if he is not satisfied with same.
Kuma hukuncin da aka ma da bai game ka ba za ka iya appeal daga nan zuwa kwana 90.
Ya game ni bisa godiya ma da nake yi.
Okay, call the next case.
FSC/DM/CR/44/2023 between the Federal Republic of Nigeria and Damaturu.
My lord, the defenders here at the correction center and he speaks Hausa.
Yes. Representation.
Respectfully, my lord, I am AI Waziri, holding the brief of S. Adomai. Our appearance is for the defendant applicant. Thank you.
With the greatest respect and much honor, my lord, my name is Usman Bamala. My humble appearance is for the complainant respondent.
Respectfully, my lord, we have an application before this honorable court, and we are ready to make same.
Go ahead.
Thank you, my lord. Our application is a motion on notice dated the 29th day of September and filed on the 3rd day of October 2023. Our motion is brought pursuant to sections 34, 35, 36 sub 5, and 41 of the Constitution of the Federal Republic of Nigeria as amended, and sections 158, 159, 162, 163, and 165 of the Administration of Criminal Justice Act, and under the inherent powers of this court. Our motion is supported by an affidavit deposed to by one Mohammed Abakar.
Can you move your motion on the terms? Yes.
As the court pleases, madam.
Yes.
With the court permission, we move my motion in terms of the motion paper. And we urge this honorable court to grant same. Thank you, madam.
The prosecuting counsel, no response? You are muted.
Thank you very much, my lord. My lord, we have not filed any counter to the application, and as such, we hold no objection, my lord.
This honorable court will listen to the application for bail of the applicant defendant. Will deliver a ruling shortly.
As court pleases.
Ruling.
Court, please, ma'am.
The defendant in this case is Damaturu, who is standing trial before this court in the 3-count charge number FSC DMCR 44/2023, dated 8 September 2023, and filed 25th September 2023. And filed 3rd October 2023. The defendant pleaded not guilty to the charge when he was arraigned. Trial is yet to commence. The defendant, through his counsel, applied for bail. Counsel moved his application on terms. The prosecuting respondent counsel did not oppose the application. The deponent in the affidavit deposed that the defendant will not commit any offense if released on bail, that the applicant will not jump bail nor in any way subvert justice if granted bail, and that the applicant is willing to meet the terms and conditions of bail. This honorable court deemed fit to impose, as he has reliable sureties within the jurisdiction of this honorable court. In determining this application, I've considered the submissions of the respective counsel. It is significant to emphasize that the recognition of bail, even though very needful constitutional as it is, the entitlement is, however, not absolute. As a matter of course, an applicant's counsel have considered the fact that the granting of bail is discretionary and cited authorities to buttress their point that discretion must be exercised judicially and judiciously. Whilst the jurisdiction the court exercises in bail application is required to be so exercised liberally in order to give effect to the provisions and spirit of the Constitution, in particular Section 36 sub 5, by which a defendant is presumed innocent until the contrary is established. The court is often concerned with one major issue in the guidelines. It is the prospect of the defendant returning to court to face his trial, where the hope is dim and there are no materials placed before the court to assuage the fear of the state that the defendant will be available to face his trial. The court, in deserving cases, even for such indictments as in this case, will ex-debitor justiciar refuse to exercise his discretion in granting bail. By the provisions of sections 35 and 36 of the 1999 Constitution of the Federal Republic of Nigeria, the courts will always want to exercise their discretion in favor of granting rather than refusing bail to a defendant accused of committing an offense which is not a capital offense. What the court requires is not for the defendant to evade his trial, but for the attendance of the defendant in court. This honorable court, having listened to the application and adumbration of the legal counsel to the applicant defendant, and after perusing the motion for bail with attached processes, hereby grants the application on the following conditions. 1, in the sum of 4 million naira and 2 sureties each in the like sum. Secondly, the first surety must be a traditional or religious leader in Yobe State. 3, the second surety must be a responsible member of the society from any sector. 4, the 2 sureties to stand for the defendant must be resident in any of the local government capitals of Yobe State, and that fact must be verified by the NDLEA as reliable. 5, the 2 sureties shall each swear to an affidavit of means. 6, the defendant applicant together with both sureties must each deposit 2 copies of their recent passport photographs with the station register of the court. 7, the defense counsel shall write a formal letter to the station registrar, Federal High Court Damaturu, to introduce the respective sureties as responsible citizens to whom the court can safely release the defendant on bail pending his trial. 8, the defendant is to provide a valid active bank account attached to a BVN number. This fact must be verified by the defense counsel as having been complied with before the release of the defendant, or the release of the applicant defendant on bail. But the application succeeds on the terms and conditions I have prescribed. Meanwhile, the defendant is to be remanded in the Potiskum Correctional Center until he fulfills the bail conditions. The substantive case was earlier adjourned to the, was it 7th November? Okay, was adjourned to the 7th day of November, 2023.
Lauyanka bai samu zuwa kotu ba, amma ya turo wakili akan ana neman belin.
His lawyer is in court.
Okay.
We are much grateful, my lord.
Yes, go ahead, Sally, and interpret to him. Still, notwithstanding the fact that he has a lawyer.
Wakilcin wani lauya wanda yanzu ya tsaya ya sarwa kotu na neman belinka. da kotu ta bada belinka da wasu sharuɗa, in an cika sharuɗan za a bada belinka, yanzu ta faɗi sharuɗa, sannan kuma za a ci gaba da shari'ar ka ainihin ta ranar 7 ga wannan wata, ranar 7 ga wata, za a ci gaba. Amma na karɓin beli kuma yau an gabatar wa kotu kuma ta amince za ta bada belinka amma an cika sharuɗa. Ka tsaya.
Call the next case. Okay, that's all for the day. Thank you, Council. That's all. Correctional Center, thank you so much.
Thank you very much, my lord.
Thank you, my lord.
Thank you very much.
Thank you, Malan Salis, for interpreting the proceedings.
Thank you, my lord. Thank you very much, my lord. Thank you very much.